Rule 2, Section 1 of the 1997 Rules of Civil Procedure provides that every ordinary civil action must be based on a cause of action. So what is a cause of action? A cause of action is the act or omission by which a party violates a right of another. China Banking Corporation versus Court of Appeals, GR number 153267, June 23, 2005. The facts in this case are as follows. Private respondent filed a complaint for a sum of money against petitioner China Banking Corporation with the Regional Trial Court of Quezon City. In its answer, the petitioner admitted being the registered owner of the home notes, the subject matter of the complaint. These are instruments of indebtedness issued in favor of a corporation named Fund Centrum Finance Incorporated or FCFI and were sold, transferred, and assigned to private respondent. Petitioner filed a motion to dismiss invoking prescription. Petitioner insists that upon the face of the complaint, prescription has set in. It claims that the home notes annexed to the pleading bearing a uniform maturity date of December 2, 1983 indicate the date of accrual of the cause of action. Hence, argues the petitioner, private respondent's filing of the complaint for sum of money on September 24, 1996 is way beyond the prescriptive period of 10 years under Article 1144 of the Civil Code. The issue in this case is whether the date of maturity of the instruments is the date of the cause of action. Private respondent counters that prescription is not apparent in the complaint because the maturity date of the home notes attached thereto is not the time of accrual of petitioner's action. Relying on Elido Sr. versus Court of Appeals, private respondent insists that the action accrued only on July 20, 1995 when demand to pay was made on petitioner. Okay, again, the issue is whether the date of maturity of the instrument is the date of the cause of action, or in other words, whether the cause of action accrues on the date of the maturity date of the instruments. The Supreme Court held that well settled is the rule that since a cause of action requires as essential elements not only a legal right of the plaintiff and a correlative duty of the defendant, but also an act or omission of the defendant in violation of said legal right, the cause of action does not accrue until the party obligated refuses expressly or impliedly to comply with its duty. Okay. The Supreme Court discussed the elements of a cause of action. A cause of action has 3 elements. First, a right in favor of the plaintiff by whatever means and under whatever law it arises or is created. Second, an obligation on the part of the named defendant to respect or not to violate such right. And finally, an act or omission on the part of such defendant violative of the right of the plaintiff or constituting a breach of the obligation of the defendant to the plaintiff. It bears stressing that it is only when the last element occurs that a cause of action arises. Accordingly, a cause of action on a written contract accrues only when an actual breach or violation thereof occurs. Alright? The Supreme Court further held that applying the foregoing principle to the instant case, we rule that private respondent's cause of action accrued only on July 20, 1995 when its demand for payment of the home notes was refused by petitioner. It was only at that time and not before that when the written contract was breached and private respondent could properly file an action in court. The cause of action cannot be said to accrue on the uniform maturity date of the home notes as petitioner asserts because at that point the third essential element of a cause of action, namely an act or omission on the part of petitioner violative of the right of private respondent or constituting a breach of the obligation of petitioner to private respondent had not yet occurred. Okay? The subject home notes, in fact, specifically states that payment of the principal and interest due on the notes shall be made only upon presentation for notation and or surrender for cancellation of the notes. Let's discuss another case. ASB Realty Corp versus Ortigas and Company, GR number 202947, December 9, 2015. The facts in this case are as follows. Respondent entered into a deed of sale with Amethyst involving a parcel of land. The Register of Deeds issued a TCT or a transfer certificate of title in the name of Amethyst. Stipulations in the contract included that Amethyst shall construct a building based on the building restrictions provided therein. Amethyst assigned the property to its sole stockholder, the petitioner. The Register of Deeds issued a transfer certificate of title in the name of petitioner. Now later on, respondent filed a complaint for specific performance directed against the petitioner, alleging that the petitioner violated the terms of the deed of sale for constructing commercial structures thereon. Respondent prayed for the reconveyance of the property or alternatively for the demolition of the structures and improvements. It invoked a provision on the deed to cancel and revert the property to it in case of violation of the terms. But take note, the contract was between respondent and Amethyst. Petitioner is an assignee of Amethyst, but in this case, respondent filed a case directly against the petitioner. The RTC dismissed the complaint. Now, what is the issue in this case? The petitioner essentially seeks the resolution of the issue of whether or not Ortigas validly rescinded the deed of sale due to the failure of Amethyst and its assignee, the petitioner, to fulfill the covenants under the deed of sale. The Supreme Court held that considering the foregoing, respondent Ortigas did not have a cause of action against the petitioner for the rescission of the deed of sale. Under Section 2, Rule 2 of the Rules of Court, a cause of action is the act or omission by which a party violates a right of another. The essential elements of a cause of action are a right in favor of the plaintiff by whatever means and under whatever law it arises or is created. Second, an obligation on the part of the defendant not to violate such right. And finally, an act or omission on the part of the defendant in violation of the right of the plaintiff or constituting a breach of the obligation of the defendant to the plaintiff for which the latter may maintain an action for recovery of damages or other relief. It is only upon the occurrence of the last element that the cause of action arises, as what I have mentioned earlier, giving the plaintiff the right to file an action in court for the recovery of damages or other relief. The Supreme Court observed that the second and third elements were absent in this case. The petitioner was not privy to the deed of sale because it was not the party obliged thereon. Not having come under duty not to violate any covenant in the deed of sale when it purchased the subject property despite the annotation on the title, its failure to comply with the covenants in the deed of sale did not constitute a breach of contract that gave rise to respondent Ortigas' right of rescission. It was rather Amethyst that defaulted in the covenants under the deed of sale. Hence, the action to enforce the provisions of the contract or to rescind the contract should be against Amethyst. In other words, rescission could not anymore take place against the petitioner once the subject property legally came into the juridical possession of the petitioner, who was a third party to the deed of sale. Again, for emphasis, the elements of a cause of action are a right in favor of the plaintiff by whatever means and under whatever law it arises or is created. Second, an obligation on the part of the named defendant to respect or not to violate such right. And third, an act or omission on the part of such defendant in violation of the right of the plaintiff or constituting a breach of the obligation of the defendant to the plaintiff, for which the latter may maintain an action for recovery of damages. What is a sufficient cause of action? A cause of action is sufficient if a valid judgment may be rendered thereon, if the alleged facts were admitted or proved. So what is the test of the sufficiency of the cause of action? To determine the existence of a cause of action, only the statements in the complaint may be properly considered, just like when we determine the jurisdiction over the subject matter, where the only consideration is on the allegations in the complaint. It is error for the court to take cognizance of external facts or hold preliminary hearings to determine their existence. If the allegations in a complaint furnish sufficient basis by which the complaint can be maintained, the same should not be dismissed regardless of the defenses that may be averred by the defendants. Okay? So the test of sufficiency of facts alleged in the complaint as constituting a cause of action is, again, whether or not, admitting facts alleged, the court could render a valid verdict in accordance with the prayer of said complaint. In the case of Sol Oil Incorporated versus Philippine Coconut Authority, GR number 174806, August 11, 2010, the Supreme Court held that in determining whether a complaint states a cause of action, the trial court can consider all the pleadings filed, including annexes and motions. The focus is on the sufficiency, not the veracity of the material allegations. Moreover, the complaint does not have to establish facts proving the existence of a cause of action at the outset. This will have to be done at the trial on the merits of the case. So what happens when there is an insufficiency of the allegations in the pleading? Failure to state a cause of action is a ground for dismissal. However, failure to state a cause of action and lack of cause of action are distinct grounds to dismiss a particular action. The former refers to the insufficiency of the allegations in the pleading, while the latter to the insufficiency of the factual basis for the action. Dismissal for failure to state a cause of action may be raised at the earliest stages of the proceedings through a motion to dismiss under Rule 16 of the Rules of Court, while dismissal for lack of cause of action may be raised at any time after the questions of fact have been resolved on the basis of stipulations, admissions, or evidence presented by the plaintiff. Justice Regalado, a recognized commentator on remedial law, has explained the distinction. What is contemplated, therefore, is a failure to state a cause of action which is provided in Section 1G of Rule 16. This is a matter of insufficiency of the pleading. Take note the difference. Failure to state a cause of action is different from failure to prove a cause of action. The remedy in the first is to move for dismissal of the pleading, while the remedy in the second is to demur to the evidence. All right. Okay, again, the test of the sufficiency of the statement of the cause of action is whether or not, accepting the veracity of the facts alleged, the court could render a valid judgment upon the same in accordance with the prayer of the complaint. Even so, the filing of the motion to dismiss, assailing the sufficiency of the complaint, does not hypothetically admit allegations of which the court will take judicial notice of to be not true, nor does the rule of hypothetical admission apply to legally impossible facts, or to facts inadmissible in evidence, or to facts that appear to be unfounded by record or document included in the pleadings. For the ground to be effective, the insufficiency of the complaint must appear on the face of the complaint and nowhere else. It would be unfair to the plaintiff, indeed, to determine the sufficiency of his cause of action from facts outside of those pleaded in the complaint. Now let us distinguish between right of action and cause of action. In Philippine American General Insurance Co. Incorporated versus Sweet Lines, the Supreme Court declared that before an action can properly be commenced, all the essential elements of the cause of action must be in existence. That is, the cause of action must be complete. All valid conditions precedent to the institution of the particular action, whether prescribed by statute, fixed by agreement of the parties, or implied by law, must be performed or complied with before commencing the action, unless the conduct of the adverse party has been such as to prevent or waive performance or excuse non-performance of the condition. A right of action is the right to presently enforce a cause of action, while a cause of action consists of the operative facts which give rise to such right of action. Is it clear? Let us clarify. The right of action does not arise until the performance of all conditions precedent to the action and may be taken away by the running of the statute of limitations through estoppel or by other circumstances which do not affect the cause of action. Performance or fulfillment of all conditions precedent upon which a right of action depends must be sufficiently alleged, considering that the burden of proof to show that a party has a right of action is upon the person initiating the suit. All right. In the case of Multi-Realty Development Corporation versus the Makati Tuscany Condominium Corporation, the Supreme Court held that the term right of action is the right to commence and maintain an action. The right of action springs from the cause of action, but does not accrue until all the facts which constitute the cause of action have occurred. Article 1144 of the New Civil Code provides that actions based on an obligation created by law shall be brought within 10 years from the time the right of action accrues. It is important to reckon the date when the right of action accrues, as the same is the beginning for counting the 10-year prescriptive period. Okay? The right of action accrues when there exists a cause of action, which consists of the three elements. Have you memorized the three elements? These are a right in favor of the plaintiff by whatever means and under whatever law it arises or is created. Number 2, an obligation on the part of the defendant to respect such right. And finally, an act or omission on the part of such defendant violative of the right of the plaintiff. It is only when the last element occurs or takes place that it can be said in law that a cause of action has arisen. Here is an illustration. The first element of a cause of action is the existence of a legal right in favor of the plaintiff. The second element of a cause of action is the correlative duty of the defendant to respect such right. And the third element of a cause of action is an act or omission by such defendant in violation of the right of the plaintiff with a resulting injury or damage to the plaintiff, for which the latter may maintain an action for the recovery of relief from the defendant. Although the first two elements may exist, a cause of action arises only upon the occurrence of the last element, giving the plaintiff the right to maintain an action in court for recovery of damages or other appropriate relief. In one case, the Supreme Court held that the petitioner's right of action could only spring from an existing cause of action. Thus, a complaint whose cause of action has not yet accrued cannot be cured by an amended or supplemental pleading alleging the existence or accrual of a cause of action during the pendency of the action. 4. Only when there is an invasion of primary rights, not before, does the adjective or remedial law become operative. Verily, a premature invocation of the court's intervention renders the complaint without a cause of action and dismissible. In said case, the Supreme Court held that there is neither any showing of compliance by petitioners with the requirements for the filing of a notice of claim within the prescribed period, nor any allegation to that effect. It may then be said that while petitioners may possibly have a cause of action for failure to comply with the above condition precedent, they lost whatever right of action they may have in their favor, or, taken in another sense, that remedial right or right to relief had prescribed. Even the filing of the complaint is of no remedial or practical consequence, since the time limits for the filing thereof, whether viewed as a condition precedent or as a prescriptive period, would in this case be productive of the same result, that is, that petitioners had no right of action to begin with, or at any rate their claim was time-barred. Alright? Is it clear now? There is a right, there is a legal duty on the part of the defendant to respect that right, and when there is an act or omission in violation of that right, that gives rise to a cause of action. However, a cause of action is not enough to give the plaintiff the right to bring an action in court. There must be compliance with conditions precedent, like for example, as in the case that I have just discussed, the filing of the notice. Failure to comply with the conditions precedent does not give rise to the right of the plaintiff to file an action in court. Other examples of conditions precedent include that it must be brought within the prescriptive period, or that demand or notice, if required by law or agreement, must be made. So, for example, in a loan and it has defaulted, that could be a cause of action because there is already a violation of the right. However, it does not give rise to a right of action before the plaintiff demands the defendant the payment of the defaulted loan obligation. Even if there is default, a person cannot go to court directly because there must still be compliance with the demand or notice. It is only upon the compliance with the demand or notice upon the defendant, and then the defendant fails to pay, can the plaintiff file an action in court, and that is his right of action based on a valid cause of action.